Obviously an error, corrected. The court, when it granted that order, did have the power to provide the time frame. So the defense simply made an application to say the state must provide the state paper, the state must provide the state papers to the defense. But right now, that error which was specifically apparent must be rectified in that this court today must provide a specific time frame for those state papers to be furnished to the defense. So the court said they want to inquire if they have such power to order such an application. I'm also equally shocked, to hear the court saying they want to inquire if they have such power, because last time on the 18th of August, the state made a similar application, a similar ruling. So why would the court then say we need to inquire if we have such power, when on the 18th they made a similar application and a similar finding that they have the power to order the state to provide the state papers on such and such a specific date? In our view, they simply have that power to do that because we've got a precedent. They did so on the 18th.
So why are these papers so important? Why do you need them?
It's the accused person's constitutional right. He has to be served with his state papers so that he prepares for his defense. They are the case. The case cannot be prepared, a defense cannot be prepared without the state papers. We cannot be ambushed. The Constitution says state papers must be provided within reasonable time. That's what the defense is simply asking for. Reasonable time to have state papers so that we prepare our defense. That's it. It's a constitutional right, and they've got a constitutional mandate to do so.
Do you think these are deliberate tactics to delay trial and keep Job Sikhala incarcerated?
I wouldn't want to say much on that. I could be misquoted, but I want to implore the state to simply comply with the provisions of the law.
I'll be more direct and say yes, it's a deliberate strategy to delay trial. We made that application because we knew that the state did not have the state papers. The state is not ready to proceed with this matter. The state absolutely have no evidence against the truth. They simply want to keep them in custody for as long as possible. They only raise the issue of having completed investigations for the purpose of defeating an application we had made for challenging continued remand. So they are coming up with story after story to challenge an application that would have made before the courts.